Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. Keith Fuicelli here for another episode of the Colorado Trial Lawyer Connection podcast. And for those of you who are regular listeners, you know that we love to have Colorado trial lawyers on, talking about recent cases that they tried, issues in the case, what worked, what didn't work. And so with that, I am very excited to finally get Spencer Kontnik on the podcast from the firm of Kontnik Cohen. Spencer had a phenomenal result involving Denver Health, and really excited to have Spencer on the podcast to talk about that amazing verdict. And with that, welcome to the show, Spencer.
Yeah, thank you, Keith. I'm excited to be on the show.
All right. And I'm excited because as you and I were talking before we started recording, I'm just going to confess that I really know nothing about employment law. I mean, I have some general ideas about things like harassment, but I know nothing about accommodations or anything along those lines. So I'm excited personally to get to learn more about that area of law. But before we dig into employment law and this specific trial, Spencer, tell us a little bit about yourself. Did you always know that you wanted to be a trial lawyer?
So sort of. I mean, I knew that I wanted to get into law. I started off in undergrad being really into politics, and I went out to Washington, D.C., and I was working for former Senator Mark Udall out there.
Okay.
And he had a few attorneys on his team, and I remember just the way he would talk about, politics and the law and legislation with the attorneys, and he gave such deference to the attorneys on his team, and I was like, all right, I want to be in that position. But that's kind of what prompted me to go to law school. But then once I was in law school, I did trial courses with David Shaw, the director of advocacy over there at DU. And I fell in love with trial work right away. And I knew that's what I wanted to do.
It's funny because you're not the first lawyer that has been on that spent some time in D.C. and then went on to realize that their calling was in law. And then certainly not the first lawyer to come in that got bit by the trial bug through trial advocacy at law school. So where did you do your undergraduate degree?
So I did my undergraduate at the University of Colorado Boulder. And I started working for then Congressman Udall, and I worked with him when he switched to the Senate. And then I did, my law degree at the University of Denver.
Great. Well, I'm also a Buff, so go Buffs. Shout out to the University of Colorado. Did you major in political science?
I did.
All right. Did you have
kind of a beaten path?
Did you envision yourself running for Congress? Is that potentially in your card someday?
I doubt it. I mean, we could see things change. I love what I do. I love being an advocate. So, I mean, I'll tell you, when I first graduated from law school, I got a job doing defense work for an employment defense firm.
Okay.
And one of the first big cases that I handled was actually a defense case where a deaf individual had applied to work for a company, and they were not hired, and they filed a lawsuit without an attorney, and we were able to get the case dismissed. That was my role as, a defense attorney doing my job representing the company. But I remember litigating that case and being on the defense side of things, and I was although I loved the area of law that I was practicing, I really wanted to be in a position where I could help an individual like that pursue their claims. So that's what prompted me to say, hey, I want to switch it up. I want to set up my own firm, and I want to work on helping people who, need the help to address discrimination and that type of form.
Yeah, what I love about that story is it's aligned with the story I tell myself about many defense lawyers that, they're passionate about the law and about representing their clients. And then they go and they get this victory, but then they have to, in a way, like live with the victory. And then in my magical unicorn world, the reality of what they've done starts to set in, and then they come to this epiphany. I'm on the wrong side. I'm going to go help people. And it kind of sounds like that happened with you. Is that accurate?
Yeah, 100%. And I think for me, it became very clear that it was a calling for me beyond just kind of switching from the defense side to the plaintiff side. So I'm actually deaf in my left ear, and I have a profound hearing loss in my right ear.
Okay.
And so, for the longest time, I wanted to do everything that I could to distance myself from anything disability related. I didn't want people to think that I was less capable than because I have my own disability.
Sure.
But then being in that position, I realized like not only do I have the skill set and the expertise to be able to help this person, but I have, the personal lived experience to be able to relate to some of my clients in a way that maybe other attorneys can't. And so, it was really kind of like a light bulb went on, and I was like, all right, like I want to be in a position where I'm advocating for individuals with disabilities. And so, a big portion of my practice is plaintiff employment work, but then we also do a lot of disability discrimination that comes up in other contexts. And it's like, all of my life and lived experiences have kind of like come together in a way that I can advocate for the community that I'm a part of, which is pretty cool.
Yeah. Could you talk to me a little bit more about what that feels like for you to be able to represent people that have similar, is it appropriate to use the word disability, similar obstacles to their lives? And here you are living that firsthand. I just can't imagine that doesn't give you this sense of connection with your clients that makes them feel instantly at ease.
Yeah, I mean, I think, first of all, in terms of using the term disability, I have no issue with that. I think that's a personal thing in terms of addressing it with everybody. Some people may not be comfortable with that. It's very, how does anyone identify in that regard? But it does give me, I think, at least from my perspective, an ability to connect with my clients in the sense that, like, I have experienced sort of the struggles in terms of getting accommodations that I need to allow me to perform my job. For example, I'll have CART interpreters, which is communication access real time. It's like essentially subtitles when I'm in the courtroom.
Okay.
And a lot of people just don't have any experience with that. They don't know what accommodations are available, and they don't know what individuals with disabilities maybe can do when they have the accommodations in place to be successful.
Okay.
And I think I'm an example of that. And so I'm able to kind of use my lived experience in addition to my legal expertise. And I think that's comforting for clients in some respect because, they know that, I'm there for the fight, not just because it's about, the money or because it's about, the prestige of the case. It's something that's personal to me.
Wow, that is so profound. And I just can't imagine how comforting it must feel with clients working with you and the passion that you bring to it. Because like you said, when you have that sort of first lived world, it's not about money. It's not about winning the case. It's about really trying to effectuate change for your clients in a way that it just seems different and deeper in a way than if that were not the case. Is that accurate?
Yeah, I think so. And it's funny, Keith, because we talk about it in the sense of it being a disability, but, it goes back to like what I remember when I was a little kid. Like, my parents would talk about my hearing loss and they'd tell me it's your super ability. It's going to be your superpower, right?
Right.
And, in a lot of ways, it kind of like, it works that way. For example, like in trials that I do, one of the first things that's so challenging is figuring out like, how can you relate to like a potential jury or be vulnerable in front of a jury, and like having that like initial communication where I have to get out there and tell a panel like, look, like this is going to be challenging for me. I've got a CART interpreter. I'm reading what's going on. I may have to ask for a pause here and there. And that can be very
scary.
It's intimidating. It's scary, but I think it also kind of it takes down the wall a little bit, and it helps build that level of trust with a jury or a judge or whoever it is that you're working with, and like that becomes like an asset for me rather than a hindrance, you know?
Yeah. As you're talking about that, I'm hearing sort of the Jerry Spence-esque getting up in front of the jury and just like laying your soul bare and your fears about what's going on. And the jurors are instantly like, okay, I like this guy. He's in here fighting the good fight. And I also love what you're saying about how sometimes things that seem bad turn out to be good. And a couple of thoughts come to my mind when you're talking about that. My son has type 1 diabetes, and he's had it since he's a sophomore now in high school, and he had it since he was like 6 years old. And that kid is so resilient. I know type 1 diabetes is, really not that big of a deal, but it kind of is. And he's celiac, so he can't eat gluten. And the kid has had these adversities, but now it's like things just bounce off his back. And the other thought is, a lot of people might not know this about me, but I am a brain injury survivor. So I actually suffered a pretty severe brain injury in 2007. And at the same, when all that was happening, I was in the sort of acute phases of recovery, all this self-doubt, am I going to be able to get in front of a jury? And fast forward 15, 20 years later, and now I do feel like it's kind of a superpower, because it's like I can get up and simplify things and connect with people much differently than I could have before. So I just love that story of turning something that seems like an obstacle and then working it to your advantage. So kudos to you. That's just amazing.
Yeah, no, and I mean, I think, this case that we're going to talk about, I mean, this is just sort of right up that alley in terms of, me having to confront some of the challenges that I face, but then also my client, who had the number of diagnoses and disabilities, for her going in front of a jury, like it was so brave of her, and it was something that we had to talk about, time and time again to kind of figure out, like, is this something she even thinks she can do? And that was,
You mean the trial? Whether
Yeah.
she could even do the trial is what you're talking about? Yeah.
Yeah.
So let's dig into the law a little bit, because like I said, I know nothing. And I kind of want to start with the case that you got the defense verdict on, where the person went in. Did I hear you had some sort of deafness, applied, was never interviewed? So just what is the law? When are employers required to provide accommodations, and when are they not?
Well, so that's a loaded question.
Okay.
So, I mean, employers are required to provide reasonable accommodations to individuals with disabilities. So, first, you have to have a disability, and it has to limit a major life function. I mean, that can be anything from reading, walking, hearing, having an attention span, being able to lift something heavy. And then employers have an obligation to provide a reasonable accommodation. And so that's where juries and judges and fact finders come in to figure out what is reasonable.
Okay.
And so in the context of somebody who is deaf, a lot of times that would be a sign language interpreter, or maybe providing something in writing so that they can understand, as opposed to verbal instructions. In our case, our client had several diagnoses. She had a seizure disorder, short bowel syndrome, and she suffered from depression and anxiety. And so she just requested a flexible working schedule, which is actually a very common accommodation request that we see in the context of employment. But it really focuses on the individual, and that's the crux of any disability discrimination cases. Does the individual have a disability, and is there reasonable accommodation? And are the parties working in the term is an interactive process, but are they working together to try to find a way to accommodate this person? And so I think, one of the things that you see often is like, did the employer actually meaningfully work with the individual to accommodate them, or were they just sort of playing lip service to the nature of like, oh, we're going to accommodate you, but not really, if that makes sense?
Is there a lot of resistance in the employer world where, the initial reaction is depending on what the diagnosis is? So I can imagine that some disability diagnoses are clear. And others, if they're psychological in nature, would be very subject to the employer saying, oh, come on, you want me to do what? And feel like maybe they're being taken advantage of. Talk to us a little bit about what is required to prove the actual diagnosis piece to thereby shift the burden on the employer to make accommodations.
So that initial burden is actually, it's a low burden. So the focus of any disability discrimination case is really, it's more about that interactive process and the parties working together. So really, if you can establish a diagnosis or you have a doctor's letter or anything to that effect, that usually is enough to kind of meet that initial burden to get the employer to engage with you. The question then becomes, what is reasonable based on this diagnosis? And so an example that you see oftentimes come up would be, someone who has a processing disorder.
Okay.
Right? For example, maybe somebody who has ADHD, right?
Yep.
ADHD can be minor or it can be extremely severe. So a diagnosis of ADHD doesn't necessarily mean that accommodations are needed, because a relatively mild diagnosis of ADHD, maybe there aren't any accommodations that are needed, or maybe there's very minor accommodations that are needed. But then there are some people who have much more severe symptoms and manifestations of ADHD. And so that's why the focus of any case is kind of, what does that individual need and what are the accommodations that are reasonable for that individual? Because no two diagnoses are ever exactly the same.
And I'm also, in my mind, hearing that whether what the employer did is reasonable is also fact specific, because I'm wondering, what if it's a tiny employer? What if they don't have the ability to meet financially the accommodations that are needed? So are all those factors play into whether or not what the employer was doing was reasonable?
Absolutely. So, I mean, the first analysis is whether the accommodation itself is reasonable. And the accommodation in this case that we had with Denver Health was a late start time.
Okay.
But, I mean, then there's a second analysis, which is this a fundamental alteration or is it an undue burden for the employer?
Wait, so talk to us about that first one, a fundamental alteration. What does that mean?
Yeah, would it fundamentally alter the services? So one example that I'll give, I use myself as an example a lot, just given that I have a disability. If, for example, a 911 call operator was hiring for someone to answer calls and, take down information in the event of an emergency, I would probably be a very poor candidate for that job, given that the core of the job is being able to hear and take the information in, and I actually need an interpreter oftentimes to be able to understand somebody with an accent, right?
Got it. Yeah.
Asking me to perform that job, you would have to fundamentally alter the nature of the job for me to be able to perform that job, because I can't hear people who have an accent, or in certain situations, like if there's sirens in the background or something like that. Then you have like an undue burden, and that is really more focused on, is the accommodation going to be too expensive, or is it going to make it too difficult for the business to operate by providing that accommodation? And so those are really the defenses that employees use to combat an accommodation request.
Are those affirmative defenses? Is that how that works? So they have so the burden then shifts to the employer to sort of prove that piece of it?
Correct.
Another probably dumb question for you. I mean, dumb question for me, but you obviously know this. But are all these under the Americans with Disabilities Act? Is that how all these claims are brought?
Yeah. So we actually brought the claim under the Colorado Anti-Discrimination Act. That's actually something that we've been doing often. The remedies under CADA, which is the Colorado Anti-Discrimination Act, are very similar to the remedies under the ADA. And so we have been bringing a lot of cases under state law. I think we would like if possible, to try to stay out of federal court, not necessarily because, federal court is bad. I'm comfortable litigating in federal court, but because we can get a jury trial in a year, right? And in federal court, we're often having to wait 3 to 4 years before we can even get a trial. And so having that option to go to state court under CADA is huge because it allows our clients to get relief in an expedited manner.
So talk to us a little bit about what kind of damages are available in cases like this. So you've got, before we get into the facts of this case, we'll play with a hypothetical. So someone is hired, they have a disability, the employer is not providing sufficient accommodations, person ends up having to quit the job. In that kind of hypothetical, what types of damages, remedies are available?
Yeah, so you've got a couple of different categories of damages. The first is back pay.
Okay.
And so that's just what they could have earned during that period after when they quit or they were terminated or not hired or whatever the circumstances is. The second is front pay. And that is sort of a reasonable calculation of what they could have or would earn going forward. But then you have to take into account any mitigation that they may have. So if they get a new job, that would mitigate their front pay damages. The third and fourth category, it's compensatory damages and punitive damages. Both of those categories of damages, though, are limited based on the size of the employer. So if you're a small employer, those damages may be $15,000. The maximum that they can be for a very large employer is $300,000. You cannot recover more than $300,000.
Okay.
And then the final category of damages is attorney's fees and costs that you bring in pursuing a lawsuit.
Are attorney's fees and costs as of right, or is it a discretionary function of the trial court? How does that piece work?
So it is discretionary. However, it's pretty well established within Colorado, the 10th Circuit, most jurisdictions, that if you win, even if it's not a big win, you are entitled to your attorney's fees and costs. But, a judge obviously has discretion to use the go-to-start method to try to figure out, what is a reasonable amount of fees and costs based on the results of the case.
So it seems like a good system in the sense that there's an incentive for lawyers such as yourself to sometimes take maybe smaller value but righteous cases. Is that how it's designed, and does it work that way?
I would say no.
Okay.
I think a huge challenge is that, those lower value cases, even if liability is strong, working that up on an IOU basis is not really an attractive option.
Okay.
And it's actually one of, we talk about caps in the context of personal injury, all the time. That is a huge struggle in employment cases because in those cases where there's very strong liability, but maybe they're a minimum wage worker and they find a new job, 6 months after, they're going to have a very difficult time finding an attorney to take that case. And so it's sort of a missing piece. And it's why employers, I think, sometimes don't get it right because they're able to make a lot of mistakes along the way. And so many people can't vindicate their rights along the way. And so the employer kind of gets into a pattern of acting in a way that maybe they shouldn't be. And then you just got to wait until you have the right case at the right time to kind of go after them for that.
Is there a notice requirement for smaller companies? Because in my mind, I'm thinking, sure, big companies that have an HR department, they're fully aware of this law and accommodations they need to make. But I'm thinking of, a 5 or 10 employer shop, they might not know. Is there some sort of notice, both, I guess, practically and legally, that needs to be given to the employer that says you're required to provide accommodations, here's what you need to do, and here's what I'm requesting?
So, practically speaking, the employer has to be put on notice. So the individual with the disability has to come forward and make some sort of complaint or request an accommodation. If that doesn't happen, regardless of how big the employer is, there's no way. They're going to have a very difficult time trying to bring a case.
I guess that was that we can both agree that was a dumb question, because of course at some point you have to say, hey, employer, I need you to do something, and the employer needs to say no. So I retract that terrible question.
I don't think there are. I mean, Keith, really, there aren't any, in my experience, there really aren't any dumb questions in the context of this area of law. Like, one of the things that I like about it so much is that it's like, a lot of times, not always, but a lot of times when I'm litigating disability discrimination cases, there's the legal component of pursuing the case legally, but then there's an education component in terms of being able to teach people about, here are the accommodations that are available. Here's what you need to know. Here's what you should be aware of. But the one thing I'll tell you, and I mean, you may know this, but for any employment discrimination case, you have to exhaust the administrative remedies first. So you have to go file a charge of discrimination with the Colorado Civil Rights Division. And in terms of a legal prerequisite, that's pretty helpful because, you have the ability to mediate claims and sort of address claims before you get to the point of filing a final lawsuit.
So I definitely did not know that. How important, I know that from dealing with like long-term disability type policies, those types of cases, that the administrative remedy piece is critical. And sometimes people make mistakes because they try to do it on their own, and they need lawyers to help set the record that can then be litigated later if need be. How important in the disability employment context is that phase where you are going through the administrative process?
I mean, it's critical. I mean, first and foremost, you have to do it, or you're going to lose the ability to file a lawsuit. And it's 300 days, so it's a relatively quick timeline in terms of when you can file. But it's also very important because in the context of employment cases, a lot of times you have clients who come to you and they're sharing their experience in terms of like what they went through, but the administrative process allows you to sort of get a full picture in terms of what happened. And so you can gather a lot of evidence during that process that will help inform you of how strong a potential client's case is. And so that can be a very strong tool in terms of evaluating, is it a contingent fee case? What is the chances of liability? Are there, circumstances that, demonstrate that this employer has had issues in the past. So you can find out a lot of information during that process.
So does the state do an active investigation, sort of like the way the police would? I mean, they're sort of like, in a way, hopefully proving your case for you, or no?
Sometimes.
Okay.
So the state, I mean, there's the Equal Employment Opportunity Commission, the federal agency, and the Colorado Civil Rights Division, the state agency. They're both overwhelmed by the number of cases that they get. Sometimes you get a little bit more of a detailed investigation. Other times you just get a letter saying, go file a lawsuit if you want to file a lawsuit. It just depends.
Got it. All right. Well, let's talk about the facts of a case that you were able to take to trial. And this, I know, is not a dumb question, but is this a jury trial or is this a court trial on these types of claims?
Yeah, so it's a jury trial.
Okay.
But it's a little bit interesting because back pay and front pay, which I talked about earlier, those are equitable remedies. So those are determined by the court.
Okay.
Punitive damages and compensatory damages are determined by the jury. So you have a jury trial essentially on liability to determine what are the compensatory damages, if any, what are the punitive damages, if any. Then the court will assess what are the economic damages related to front pay and back pay. Then the court will also make a determination on attorney's fees. So it's sort of a hybrid between a jury trial and a bench trial.
So, all right, well, let's dig into the case that you tried. Give us a little bit of the background of what the playing field was. What were the facts?
Yeah, so we represented an individual. Her name was Kimberly McVan, but she is non-binary. She was known to me as Kim. She was is a biostatistician. She's got over 130 peer-reviewed publications, very well respected in the field. And she had been working for a prior company, and then she had the opportunity to take a job at Denver Health.
Okay.
And Denver Health made a pretty significant offer in terms of compensation. So she put in her notice with the other company and accepted the job with Denver Health. And shortly after accepting the job, she engaged with Denver Health HR department about requesting accommodations based on her diagnoses. As I think I mentioned earlier, she has a seizure disorder, short bowel syndrome, Asperger's, and then she also suffered some depression and anxiety.
Okay.
And once Denver Health got notice of her request for accommodations, they started delaying her start date, and they did that a couple of times. And then they eventually just rescinded the offer entirely.
Wow.
Which left our client kind of hanging because, she had left her previous position to accept that job. She had accepted the job. She made the accommodation request. But then after that, Denver Health, just for whatever they were doing internally, decided we don't even want to engage in the accommodation process, and we're not going to provide a job anymore. And so, it was an interesting case because it was a crossover of discrimination and retaliation, right? Like, because you
Sure.
have the discrimination component of it as like they're discriminating against her based on her disabilities, which they were made aware of, but it was also they retaliated against her because she made an accommodation request. And ultimately, the jury determined that it was not discrimination, it was retaliation. And that's how they determined that liability was warranted against Denver Health.
Is there a legal significance to that finding, or does it not matter as long as you win on one or the other?
It doesn't really matter in terms of winning on one or the other, but I think there's a pretty powerful message there, and there is a legal significance in the sense that it really sends a message to employers that you can't discriminate or retaliate, whichever terminology you want to use, based on a request for accommodation. So,
Okay.
and that's really important because I think a lot of times individuals with disabilities, they're afraid to even ask
Yeah.
because they're afraid that their employer may say, we're gonna terminate you, or we're gonna subject you to some form of retaliation or different procedures in the workplace. And so the message from this case, from my perspective as a plaintiff employment attorney, is that, individuals with disabilities, they need to have that freedom to be able to request the accommodations that they need in the workplace, and an employer cannot retaliate against them for making that request.
And can you end up in a situation where you almost end up with like a hostile work environment as a result of that's the form of the retaliation?
Absolutely. And I mean, I think you see a lot of situations where, employers just keep asking questions and keep asking questions instead of focusing on, how can I accommodate you? They sort of have this fear that, like, oh my gosh, this individual has a disability, they may not be able to perform the functions of their job. And so, it can create sort of a slippery slope in terms of how people are being treated in the workplace. But in this case, they didn't even get to the point of working with our client on accommodations. They just rescinded the offer in its entirety.
So what did they say in depositions about why they rescinded the offer? Did they come up with some kind of excuse?
Yeah, so they essentially said that accommodating our clients' requests for a late start time would be a material disruption to the business. She wanted to start 1 hour late, and therefore they could not accommodate her, and they would not provide her with a position. And so it was, it was a disappointing defense, but it was interesting because what they tried to do is they tried to frame the case about the managers who made the decisions, and so they tried to make the case about those managers and argue that they're not discriminatory. Like, they don't decide disabled people. They were just trying to make a good decision for the business. Right? They didn't have a discriminatory animus. And so what the trial really became about, and what we had to really focus on is, actions speak louder than words, right?
Okay.
Because we don't necessarily, it's very difficult to prove that individual, that person is a discriminatory person. They don't like disabled people. That's
Yeah.
very difficult to prove. And so what we had to do is we had to kind of cultivate the evidence and cultivate our cross-examinations and our lines of questioning to show that the way they treated her and the actions that they took, those were discriminatory. And that's ultimately how we were able to kind of convince the jury that it's like, this was discrimination, and it doesn't really matter whether or not you believe that specific individual doesn't like disabled people or not.
So talk to me a little bit about the specific diagnosis that the accommodation was your client started an hour later. Which of those was that related to the seizure disorder or the more the psychological depression type issues?
Yeah, so it went hand in hand with primarily the seizure disorder, but it went hand in hand with the short bowel syndrome and depression and anxiety. So as a result of all of those diagnoses, our client is on certain medications, which make it very difficult for her to sleep at night. And so she just needs a little extra time in the mornings to be able to kind of get up and get going and get operating. And that was just something that Denver Health wasn't willing to provide. But what was interesting is they would allow people to start late or miss core hours, that's what they call them, for school. So somebody could start late or miss core hours to go get, if they're in their master's program or they're trying to get a PhD, they could miss hours to go to school and then come back and be part of the core hours. But for my client, because it was related to an accommodation, they said no.
So that seems to completely eliminate their argument that it would materially disrupted the job performance if they're doing it for other people for school.
Yeah, I mean, we thought so.
Yeah.
And obviously I think the jury agreed, but, it was difficult because the managers who got up there and testified on Denver Health's behalf, they were very likable.
Yeah.
They were nice people.
Yeah.
And I think it kind of makes me, like, conceptually thinking about the case, I'm like, you could have somebody who is, a racist or a bigot, and they could act legally, right? And they wouldn't be responsible for anything that they did as long as they're acting legally, right? You can also have somebody who is not a racist or not a bigot or not discriminatory, but through their actions, they can still discriminate. And that's really like what the crux of the case was about.
Yeah, that's fascinating. So what was your, as you're talking about this, did you have a specific theme that you sort of wove throughout the case? Was it the actions speak louder than words?
Yeah. So, I mean, we really focused on how Denver Health was punishing our client for speaking out. And that was something that was sort of a theme throughout the case. We really focused on, her right to be able to ask for an accommodation and her right to be able to be free from punishment for asking for an accommodation, and Denver Health punishing her for having the audacity to speak up. And I think, that played out well in the trial. And I think it was, it was an interesting trial and like a fun trial because, our client, she has Asperger's, she's non-binary, she suffers from depression and anxiety. It was against Denver Health, which is a public institution. So, there were a lot of issues in terms of like, how do we get the jury to award, $150,000, we asked for more than that, but $150,000 in compensatory damages, for someone who has difficulty showing emotion, and for someone who some people may be prejudiced against based on, her sexual orientation and her sexual identity. And so those were difficult issues that we had to really address upfront in voir dire and, throughout the themes in our case in terms of saying you can't punish her and you can't not avoid damages because of her Asperger's. Like, that is not something that you can take into consideration. You need to evaluate the damages that she experienced and avoid damages based on what she had to go through.
Did the court give you extra time for voir dire given the complexities of your case?
So we got a little bit of extra time, not much.
45 minutes or something?
Yeah, around that. Okay. Yeah, something like that. Yeah.
The other question that came to mind is, what did Denver Health have an excuse? why they didn't hire her? Is it just does that go back to their position was what she was requesting fundamentally changed the job, and therefore they rescinded the offer, and they kind of owned that was the reason why they rescinded the offer?
So it was sort of, I think they maybe had two different theories that they were trying to, use at the same time. One was she couldn't do the core functions, so she couldn't do the job. No viability in that regard. Okay. The second issue was they claimed that she became combative during the accommodation request process. So essentially they argued that she didn't follow through with her obligations to engage in good faith in the interactive process, which in some respects did happen a little bit because, my client left her job, accepted the job, then they kept delaying her start date. And so my client was getting upset because she was like, hey, I left my job. I'm the breadwinner in my household. I don't have an income. What's going on? I need to start. And so there was some frustration from my client. And so they tried to point fingers at her and say it was her fault because she was being combative. And that was the second component of the trial that we really had to address. And I think, again, a big challenge here was figuring out, how do we draw sympathy towards our client when, she has that Asperger's diagnosis and she's not up on the stand crying and, maybe exhibiting some of the emotion that some of us would expect from someone in that situation.
How long did the trial last?
So it was a week-long trial, and then we had a one-day hearing on damages post-trial.
All right. So talk to us a little bit about what your ask was, what the verdict was, and then what happened post-trial with the court determinations.
Yeah. So our ask, figuring out the ask, there's different asks, right? Because there's the ask to the jury for compensative and punitive damages, and then there's the ask to the court for economic damages. In terms of our ask to the jury, we asked for $600,000.
Okay.
Our thinking here was that the cap on damages is $300,000. We thought the jury might have it, or I guess in this case, quarter it.
Okay.
But my hope was that the jury was going to half it and would get the full $300,000. It was, in terms of proving emotional pain and suffering, there wasn't much beyond our client's testimony. So it was a little bit difficult to figure out, how do we make an ask of, $1 million or something, in excess of 7 figures, because it was really predominantly related to her emotional pain and suffering, the physical symptoms that she experienced from the pain and suffering, related to her short bowel syndrome and, her depression and her anxiety and the panic attacks that she had. That was really the focus of it, but there was no PTSD diagnosis or anything like that we could rely on.
Okay.
So the jury came back with, I think an award that we're happy about. Obviously, I'd love to see a higher award, but for that level of award without having any documentation of PTSD, I think, that was something that we were pretty proud of.
What was the award then?
It was $150,000.
Okay. And do you get interest on that from the sort of prejudgment interest back to the day of the wrongful action?
Yeah, so we got $15,099 or $16,000 in prejudgment interest.
Okay.
And then we had a claim for $130,000 in back pay, which went to the judge. And we had an expert who opined on our client's period of back pay and front pay. So we had asked we got all of the back pay that we requested, which was $130,000. We asked for 7 years of front pay, and the judge gave us the equivalent of about 2 years.
Okay.
A little bit more than that. So it was $205,000 in front pay. It's interesting because, I think the judge was in a difficult position with this front pay case because our client had found a job, but then was terminated in her subsequent job as part of a mass reduction in force. Oh. And so our judge had to sort of engage in sort of a speculative fact-finding mission to figure out what is the amount of front pay. We had a damages valuation that put it at about 800 something in front pay, but we ended up getting 205.
Okay. And this was in front of Judge Gerdes, correct?
Pardon me?
Judge Gerdes was your judge here?
Correct.
And how was she?
She was good. You know, I don't really have any complaints. I think, you know, if there is one issue, I think she dealt with a lot of stuff at trial that maybe could have been dealt with pre-trial. You know, but that's common. You know,
Yeah.
I don't think that's, you know, all that big of an issue. You know, I think it was a difficult trial in the context of, like, you know, I had accommodations, my client had accommodations, we had to break often for my client to go to the restroom. I mean, there were just a lot of issues that we had to address during the trial, and I think, you know, I think she did a pretty good job handling it, and we're happy with the award. Obviously, you know, we were hoping to get more, but we're happy with the award.
Your client was happy with some sense of justice in this case. Did you get a chance to talk to the jurors afterwards?
No. We tried to, but they were out of there. One juror found my associate in the parking garage after the trial, and I mean, this is always the case, but it sounds like there was one holdout. And one juror who, like, just didn't even want to find liability, and everyone else, it sounds like they wanted to find liability and they wanted to do the full 600.
Wow.
But, you know, I mean, we did the best to get the jurors out that we could. We got 2 jurors stricken for cause, one based on their connection with Denver Health, and then one based on their view of non-binary, you know, people.
Yeah. That must have been very challenging in voir dire to create the space that people could feel free to almost verbalize their own prejudice. I can't imagine how you go about doing that.
I don't know. I mean, I like what I did. I think I could have done it better. I mean, I went back and I read through the transcript, and I was like, you know, I think I tiptoed around it a little bit, and then I just straight up, you know, went right into it. What is your opinion on non-binary people? But I tried to do it first, which sort of worked, but I don't think it was needed, to be honest. I tried to just straight up say, okay, everybody, who knows Kris Jenner? What are your opinions on Kris Jenner? Just to try to get people talking about, you know, sexuality and sexual orientation and see if people had strong opinions. I think that worked to an extent because I was able to identify a few people who seemed to have pretty strong opinions. And so I was able to follow up question.
Yeah.
You know, but I think really what was the most effective is, you know, what are your thoughts on non-binary people? And just kind of go right through it and just straight up ask him.
Well, you know? Am I correct that wasn't the real accommodation piece? Is that just more of a bias against your client piece? Because I'm not hearing the employer should have made some kind of accommodations for that. It was more the short bowel syndrome, which I'm not familiar with. What, just in case any of our listeners ever come across that with their employees or something, what's the story with that diagnosis and what are the accommodations?
For which diagnosis?
For the short bowel syndrome, I think is what you were saying?
Yeah.
Tell me about that. I've never heard of that.
Yeah, so, I mean, it's related to her depression and anxiety, but, you know, without going into too much gory detail, our client goes to the bathroom often.
Okay.
And it will become excruciatingly painful. She'll become dehydrated. Sometimes bleeding would occur based on, you know, the amount of pain and the amount of pressure down there. I don't want to get into, like, too much detail, but that was something that she did have to share during the trial, and that was a pretty compelling moment of the trial in terms of, you know, people getting some insight into what it means to live with short bowel syndrome, because a lot of people don't really have an understanding of how that affects you on it.
I mean, I'll be honest, like, I've never heard of that diagnosis, and I'm getting a visceral response hearing about it. Did you have a medical doctor come in to talk about that, or did you just do it through your client?
We just did it through our client.
Okay.
We had her therapist that testify. that was a little bit more related to the depression and anxiety and our claim for $150,000 in terms, well, $600,000 in terms of compensatory damages. And that's really why her non-binary status came up, because I've known her as a she, Denver Health knew her as a she, her therapist knows her as he. And so we knew that was going to be an issue in the trial, and it was something that we were just like, okay, like how do we handle this? How do we get in front of, her diagnoses, which are critical to this case, and any potential prejudices that people may have, and like any confusion that people may have in terms of like, who are we talking about? What are we talking about? But I think it went well in terms of being able to address those issues up front. I mean, a lesson for me in terms of takeaway is that there are difficult issues that you have to address in terms of like voir dire and opening and stuff like that. But just being straight up with the jury was most effective. I mean, you don't need to sugarcoat it. Just get right after it. And we got honest answers from him.
Wow. I mean, what an amazing result. The sense of pride you must have felt for achieving justice for your client, I just imagine was immense.
Yeah, no, it was, I mean, just, I'm sure any trial lawyer is going to understand, but like, when the jury came in, my co-counsel, Matt Fennicle, he was awesome in the trial. He's sitting there right next to me. And then our client is sitting right next to him, and, she grabs his hand. The verdict comes in, and the first verdict is on discrimination. They find that Denver Health is not liable. And like everyone's heart sinks. They're like, oh my gosh, like how did we not?
Yeah.
Like, we put on such a good case, and then they come back with the retaliation and they find liability, and they hit them with $150,000 and compensatory damages, and we're like, yes, like, we'll go get your economic, we'll figure everything else out from here.
Wow, that is so inspiring, and I just want to thank you for bearing with me and all my questions and helping educate me on an area I really knew nothing about. What's the best way for people to get in touch with you if they want to run a case by you, co-counsel, or just have questions about this pretty fascinating area of law? How do people find you?
Yeah, just call us. Our number's on the website, 720-449-8448. My email is on the website. We are not like a big advertising firm or anything like that. So a lot of our clients come through referrals and whatnot, but just reach out and I'm happy to chat.
Wow. Well, thank you so much for appearing on the show, and congratulations to you and your team for an amazing result and achieving justice for your clients. And thank you for all that you do to help this segment of the public that sometimes people just want to turn away from. They want to just ignore like it's not there, and you're out there fighting the good fight. So thank you for all that you do, and thank you for appearing on the show.
Yeah, no, thank you for having me, Keith, and thank you for all that you do here. I mean, I think raising awareness and making sure that people are aware of these issues is so important, and having the opportunity to come on this podcast and talk about it is awesome opportunity. So thank you so much.
Oh, it's been my pleasure. And thank you to all of our listeners for coming back for another episode of the Colorado Trial Lawyer Connection podcast. We'll be back again soon with more trial lawyers telling stories about how they fought and hopefully achieved justice. I suppose sometimes we have cases on here where people don't succeed, and still, we are warriors in the courtroom trying to do right. So thank you, Spencer, again for all that you do. And thank you, everyone, for listening. Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.